So today we're going to talk about future planning. We are going to focus on legal, financial, and healthcare planning. And as I had a client the other day who I told her that we're all just, none of us are getting younger. We're all getting older. And she said, no, we're just maturing. So these are all things we're going to focus on as we are maturing. So, all right. Let's see. There we go. That's me. Okay. So my name is Mary. I'm a partner at Bluegrass Elder Law here in Lexington. My law firm has 3 attorneys, Amy Doherty, Katie Fennell, and myself. And then we have 8 support staff. We work together as a team. So when you get one of us, you get all of us. And we really work on providing personalized plans for our clients that fit their needs to help them meet their particular goals, because this type of planning is not one size fits all. A little bit about me. I am the past chair, as Terry said, of the Elder Law section of the Kentucky Bar. I'm also really proud of my work with the Kentucky Guardianship Association. I just rolled off as the president of that board. The goal there really is just to help improve the guardianship process in Kentucky and give resources and education to people. So if you are someone who is involved in guardianship, I do suggest visiting our website. It's really helpful. Before we get started, you'll notice at the bottom, I've got a link. It's bgelderlaw.com/slides. I have my slides on there, and I also have some links to some materials I'll be talking about throughout the presentation. And just as a quick note, I will tell you that my first job out of law school, I worked for a probate court judge for 5 years. And that experience really helped me craft my practice the way I practice, because I have seen good lawyering, I've seen bad lawyering, and I've seen stuff that just doesn't work. And so being at a place where we resolved all the stuff that didn't work really gave me tools and ideas of how to fix things for people now so they don't come across those problems later. So, so that actually does influence a lot of my practice. I live here in Lexington. I was born and raised here. I lived in Ohio for about a decade, went to law school up there and practiced law up there, and then came back voluntarily. So I always like to say that Kentucky is it's such an amazing place, that Lexington in particular, that I came back voluntarily. I have 2 children. I have a 13-year-old girl and an 11-year-old boy who both play competitive sports. So pray for us. And let's see, what else would you always like to know about me? I had something else I was going to tell you, but I forget. So I spend a lot of time on UK's campus. I'm a sorority advisor as well. And so I spend a lot of time with the Delta Zetas. If they're ever giving you problems, just let me know. So, all right. I'm going to move on to our next slide. So we have a couple of objectives today. Really, the whole point is to understand why advanced planning is important, and to identify some tools and steps that you guys can use, talk about with other people, for yourself, for loved ones, for clients, anybody who may need them. And then to help kind of identify some specific legal issues that may come up. And so when you see these things, it'll trigger, that lawyer told me that one thing that one time, and you can remember these tools that we talked about. All right. Again, my emphasis today is also going to be on providing tools now to prevent problems in the future. A lot of this is important that we do it in advance. So, all right. So why do we want to plan now? Well, I think all of us want to take an active role in deciding things that are going to happen to us. And planning now gives us the ability to make those choices ourselves instead of waiting for someone to make them for us. Additionally, as just part of maturing, our competency is more likely to fade as time progresses. So, generally speaking, most adults who are in their 80s or older do have some memory loss of some type, and that's been seen in many studies. And living in an area like we do, where we have Sanders-Brown, we see the Alzheimer's, dementia, things like that happen, generally associated with age. So again, let's plan now. Okay. All right. So I want to talk a little bit about competency. So this is something that pops up for me in my practice a lot. I will oftentimes meet with like a spouse, and their other spouse may be in the nursing home, and they'll tell me that they're not competent to sign things. And what they mean is that their loved one has been diagnosed with dementia, or literally has some sort of physical disability where they can't sign things. It's not necessarily a determination of legal competency. And so when we're talking about planning for the future, I'm looking for a person to have legal competency. So that diagnosis alone does not mean that somebody lacks the competency to do it, a diagnosis of dementia or Alzheimer's. Kentucky recognizes something called the lucid interval doctrine, which essentially means that someone needs to understand the document they're signing when they sign it. It does not mean that they have to be able to recall all the intricacies of it later on, or anything like that. We see this a lot with individuals who have dementia and have something like sundowners. So those are the type of people who I would meet with early in the day, and to make sure that we understood the documents and were able to sign them. If someone has a physical disability where they're unable to sign, there are all kinds of ways to do that. Kentucky law allows for another person to sign on their behalf or to assist with signing. So that physical disability alone is not a bar to signing legal documents. In Kentucky, testamentary capacity, which is the legal capacity to execute a will, is really the thing we're looking at a lot. And that just indicates that a person knows who their family is able to appreciate their relationship to them, knows what stuff they own generally. Again, they don't have to have a detailed inventory, but they know that they own things. And their will has to indicate a specific disposition or indicate their wishes about how they want their stuff to be distributed upon death. And so that's kind of generally when we're talking about competency, those are the type of things that I'm looking for. Does the person know who their family is? Do they appreciate those relationships? Those are the things I am looking to find out. And that they own stuff. So if somebody thinks they own a castle in Germany, but they really have, a $200,000 house in Lexington, that's a different story. But generally speaking, people should know what they own. Okay, so I'm going to move on to the 5 important documents you need. So I'm going to throw in a couple bonuses as we go along. But generally speaking, these are the things that I want people to have and the things I tell my clients they should have. The first one is not something you would probably think of when you think of long-term care planning, but it's really just a list of things that you own. A list of your accounts, insurance policies, funeral instructions. I had a client this morning who came in with piles and piles of insurance paperwork, but we didn't really have any information about them other than they existed. So, actually making a list with the policy number, the beneficiary, the phone number for the insurance company, stuff like that is really helpful. So your loved ones don't have to dig through piles of things if something were to happen to you. Even if we have all of the correct legal documentation for someone to help access those things, if we don't know where they are, that becomes a real problem. So it really is just a list of stuff you own and where it is. So that might include even your bank lockbox, because a lot of people don't know you have a bank lockbox at your bank. And so just listing that on this piece of paper is very helpful. I do suggest that this list go with these other documents I'm going to talk about. I'm going to talk about a durable power of attorney for legal and financial affairs, a durable power of attorney for healthcare, living wills, and last wills and testaments. Those are my 5 big things. I'm going to break those down a little bit. So first, a little bit about powers of attorney. So a power of attorney is a written document where someone, we call that person the principal, appoints another person who we call the agent to do specific things for them. So the document itself should be very specific, should list out everything the person can and cannot do, or can do. There's not a lot of cannots, but if there's specific cannots, you list those too. These documents do help families avoid guardianship and conservatorship. Those generally take place when someone has lost the legal capacity to execute documents, and somebody needs to actually act on their behalf. That's the only way to go about getting someone legally appointed when another person has lost competency. The process is lengthy and expensive, And our loved ones lose the rights to vote, drive cars, own guns, all that good stuff through that process. So there are times where it is appropriate, but it can often be avoided through doing comprehensive powers of attorney in advance. It's also important that you know that powers of attorney vary between the states. Most states will acknowledge a power of attorney from another state as long as it was properly signed and executed. What I'm often seeing is the problem in my practice is someone will come from another state and the power of attorney will say they can give property as set forth in Indiana code number. They can deal with trusts as set forth in Indiana code number. And they have all these references to statutes from another state. Well, I don't think most people at the bank are going to sit down and go through the Indiana code to make sure that all of that stuff is in there. And so that's kind of where we run into some problems, which is why we want that really specific list. So, all right, going to talk a little bit about financial and legal powers of attorney. So I do my powers of attorney in two pieces, one for financial and legal affairs and the other for healthcare. The financial power of attorney needs to specifically list financial actions that your agent can take. Should also have the right to access accounts electronically, like online banking, the ability to sign contracts, the ability to deal with real estate, which can be really important if somebody has real estate and needs long-term care. The ability to gift or not to gift, it should be specific. Elder law attorneys really like gifting powers, and we like them to be unlimited, generally speaking, if the power of attorney is being executed for somebody who might need to do long-term care planning one day. That gifting power allows the agent to move assets around if we need to do that. Additionally, your financial POA needs to have enough access to your healthcare information to pay your healthcare bills. Because otherwise that gets difficult. If you can't you can't get the healthcare information to pay the bill, it's hard. And then additionally, you can choose to pay your agent under your POA. That's always an option. Healthcare powers of attorney. You want to make sure, again, that your agent can access your healthcare information and waives HIPAA. I see a lot of healthcare POAs that don't waive HIPAA. And if you're coming someplace like a big hospital like UK and your power of attorney doesn't waive HIPAA, the chances of being able to get the information you need for your loved one may be slim to none. Additionally, we want to make sure that there's some ability to make medical decisions if the principal cannot, because of their mental capacity or because of, being legally incapacitated in that they're in a coma or something like that. So those are all important powers. Just as a quick note, Kentucky updated their power of attorney statutes in 2018 and in 2020. In the legal world, that's still pretty recent. And so it's really important for powers of attorney that were signed before then to probably be reviewed by an attorney, just to make sure that they comply with the new statutes. So I do really suggest that. So if the POAs you guys, if you're seeing are short, like 3 pages or less, I see some that are half a page long. That's not enough really to provide any sort of real comprehensive planning in the future. So mine are about 10 pages long, just FYI. So, okay, let's move on to the next slide. So living wills. I'm a big proponent of living wills, which are also sometimes called advanced directives. They are a real gift to someone's family because they indicate that treatment they want at the end of their life, giving abilities to refuse or request life-prolonging treatment, to deal with feeding tubes, and to indicate wishes regarding organ donation. I just think they're really important. My own family had issues when my grandmother died. I had drafted her a living will, but you can lead a horse to water, but she had not signed it. And my grandmother had 8 children. So there were about 48 opinions about what should happen with grandma. And so there was a lot of conversation and a lot of frustration. And so something as simple as a living will that she had signed would have helped with a lot of that. Maybe not all of it because, 5 sisters and brothers as well. But I think it's such a gift to your family to have it. So if you're looking for a good, easy one. The Kentucky Attorney General's office always has one. Does not matter who the Attorney General is. They have a great packet up on their website as well. So I always suggest that. It walks you through all of the steps. There's also a document you can get from a lot of places called 5 Wishes that has a lot of these types of things in there that will walk you through the types of care you want and some additional things as well. So, all right. This is our bonus document. So I am seeing some more of these recently, so I wanted to highlight them. This is the MOST form, which is the medical orders for scope of treatment. Some states call them POST forms, which is like a portable order for scope of treatment. So these are actual medical records or medical orders that transfer with the patient. They do have to be signed by the physician as well as the patient. I typically see these for my clients who have terminal illnesses. And so these are, because it is a medical order, it is more official than a living will. So this is something that would be in your medical file. And then that's available online too. There's a link there, but there's also a link on my my slides page as well. Okay. These used to have to be printed on pink paper. They don't anymore, FYI, if somebody tells you it needs to be on pink paper. Not anymore. Okay, we are going to move on to our next slide. There we go. All right, so we're going to talk a little bit about last wills and testaments. And this is probably the estate planning document most people are familiar with because we all think that this is what controls everything when we die. So the first thing I want to highlight is that it doesn't necessarily control everything that you own when you die. So your last will and testament only controls things that you own in your own name without a beneficiary designation and without a co-owner who takes by right of survivorship. So so a lot of times for people, this might be, it depends on, sometimes if we're married, there's not that much stuff that passes through your will. So just be aware of that. But your will in general can appoint a trusted person to be your executor. In Kentucky, we call it the personal representative. And then it outlines how you want your stuff divvied up, right? Okay. So again, just highlighting what property is subject to probate. Again, it's that stuff that you have in your own name that doesn't have a beneficiary designation or a joint owner. So for example, I'm married, I own my house jointly with rights of survivorship with my spouse. So he's going to automatically get my house when I pass away. It's not a probate asset. My retirement accounts that have beneficiary designations on them will pass automatically to those beneficiaries, as will my life insurance policies. If I don't have a beneficiary on those accounts, they could end up in my probate. Sometimes life insurance companies have their own rules about what happens if the beneficiary has predeceased you or something like that. I did have one that went just directly to next of kin once. And of course, it was someone that the decedent was estranged from, but that was the way the policy was set up. So that's who got it. So just be aware of that. In Kentucky, probate is not that expensive. Generally speaking, I think probate has a really negative connotation. It's a pretty simple process in Kentucky. Again, I used to practice law in Ohio. I joked that you had to get a sworn affidavit every time someone sneezed during a probate because it was very heavily documented. In Kentucky, it is a much more relaxed process, generally speaking. Your court costs are about $300 and the probate can take about 6 months. If it's a full estate, it has to be open for 6 months. But it can be longer, of course, if you need more time to wrap things up. So I just want people to know it's not that scary. Just a quick note about trust. Trusts are probably one of the things I get the most questions about. A lot of times I get a client calling just saying, I need a trust, or I need to know about a trust. And my first question is, kind of like, why do you need a trust? So let's talk a little bit about that. There are 2 general types of trusts. One is the revocable trust, which is a living trust. That's the one that helps you skip probate. And then there's also irrevocable trust. Irrevocable just means you can't change it. A revocable trust became really popular in the 80s, 90s, early 2000s because of this whole skipping probate thing, okay? There are states where skipping probate is much more important than in Kentucky, for example, in California. Generally speaking, trusts do not provide a great, especially living trusts, do not provide a real good tax benefit if that's the reason for setting it up, unless you have more than $12.92 million. If you do, I'm happy to help you. But most of us don't ever reach that point. So I wouldn't set up a trust just for a tax benefit necessarily. For the person setting up the trust, we call that person the grantor. A revocable or living trust is not generally going to help you protect your assets for Medicaid purposes. So sometimes people want to set up a trust for that. An irrevocable trust might. We'll talk about that in just a second. So again, though, the important thing that people often skip is that these trusts only control assets that they actually own. So you can set up the best living trust in the world, but if you don't actually title any assets to it, it's not going to help you skip probate when you die. So if the trust doesn't own your house, or if the trust doesn't own your car, or isn't named as a beneficiary on something like your bank account or your life insurance policy, none of those things are going to go directly to your trust. And so I get a lot of trusts that were done in the 80s, 90s, early 2000s that come into my office. And sometimes they're even 2 binders deep, but the only thing they own is a $10 bill stapled to the back page. That's not helpful. So we want to make sure if we're using a trust that it's properly funded. Now, that being said, I currently have what I call a dry trust for myself because I have 2 minor kids, and I want to make sure that my life insurance goes there if something happens to my spouse and I. But it is not currently funded by owning something, but it is named as the beneficiary on my life insurance policy. So I have it set up that way. So again, it's serving a purpose. Let's see. Irrevocable trust can help with Medicaid planning. It needs to be the correct type of trust. So in Kentucky, we do these trusts called they're irrevocable, intentionally defective grantor trusts. Try saying that twice. So they are Medicaid. So that is the type of trust, and then the specific sub trust is a Medicaid asset preservation trust. We call them a MAPT in our office. So these trusts are irrevocable trusts where someone can place their assets, and after 5 years, they are not available for Medicaid spend downs or for Medicaid eligibility purposes. So it is a protection. However, because it is an irrevocable trust, while it is not impossible to change, it is very hard to change. Additionally, if we're doing Medicaid planning, the person setting up the trust cannot be the beneficiary or the trustee of that trust, which means they're giving up a lot of control of that. A lot of people are really hesitant to do that, and I understand why. So there we go. Okay. All right. Quick notes on guardianship and conservatorship. Since I talked a little bit about those, I always like to highlight them. Again, so the guardianship is there for when a person loses their ability to make decisions and someone has to have legal authority. I always tell people it's like you're getting a legal parent or you're becoming the legal parent of someone. If there's not a POA in place or a good POA, you may end up needing this. It is a full court proceeding. It can be a jury trial still in Kentucky. It is oftentimes just a bench trial, which is just the judge deciding. But it is a whole process. There's an attorney appointed to represent the person going through the process. And then you have to have reports from a social worker, a psychologist, and a doctor. And then those reports are read into the record. And then the person who's appointed has to file annual reports. So I generally try to encourage people to do the POAs because the guardianship process is quite tedious. All right. Okay, bonus document, funeral planning declaration. So this is a great form if you have lots of family members who have lots of ideas about how people should be buried. It's also important if you want to be cremated. In the state of Kentucky, if you want to be cremated, next of kin has to sign off. If your next of kin does not want you to be cremated, that makes it much more difficult. So I do suggest this document if you want to be cremated or if you have a specific person you want to be in charge of your funeral services and your burial or cremation. It's available online. You can even list what types of arrangements you want made, what music you want at the service. It can be as bare bones or as fleshed out as you want. So a lot of people will just do this to indicate they want it, uh, John Doe to be their person in charge of their funeral and that they want to be cremated. So that's not untypical, but it's available online free of charge. So, all right. Just a couple closing notes on the legal planning. We're going to talk a little bit more about paying for care in a minute, but I do suggest that your original documents be together in one place. I do suggest that you let a loved one or a trusted person know where this is. So when I worked for the probate court, we heard stories at least of people finding documents in really weird places. We did have a lady once who her family found a copy of her will under, well, they found a copy of her will under the floorboards by her desk in her house. And on the copy of her will was written, original in my safety deposit box at ABC Bank. Well, nobody knew she had a safety deposit box at ABC Bank, and that's how they found out. I don't know how they found the will under the floorboard, but they were able to find the original that way. So if you have your stuff in a lockbox, tell somebody. It's really helpful. And I always like to note that if you are not married and you are living with someone, you need to make sure that these documents are in place. Otherwise, it's not likely you will have the ability to make decisions for your partner. We also want to make sure that if you all have things like houses or bank accounts, that you are properly leaving those to your partner. I had a lovely client once who divorced her husband and continued to live with him the remainder of her life. Everybody thought they had gotten remarried. They had not. And when he passed away, she did not end up with any of his stuff, which, had been their original plan. So please be aware of that. I also, of course, I know I'm biased. I do not think legal documents are the times to DIY. Okay. I love to DIY. Last night, my daughter and I made a life-size stand-up of Harry Styles together. I swear to you, this was my evening was. But legal documents are not the time to do this. Please talk to an attorney. I have seen many a will from some online places cost thousands of dollars to figure out what it actually means. Because there are specific words that trigger legal connotations and legal definitions, and you really want to make sure that you have those things in place. So that is my soapbox. All right. All right. I have a question that says, I am a POA for my father, but his life insurance policy won't give me information on the policy. What can you do? So the first thing I would say is, you need to look at the policy and make sure that it gives you the ability to get that information. If not, if you are in the state of Kentucky, technically financial institutions and things like life insurance who do not take your POA can be sued. So usually an angry letter or phone call from a lawyer will get you there. But it is possible that the POA does not have sufficient language in it. That happens sometimes. Again, POAs are really dependent on the wording. And so that could be a problem there. So, all right. If you guys have further questions on legal documents, feel free to pop them in the chat. It was an elder care attorney. So the sufficient language should be in there. I would tell you to possibly contact the attorney who drafted the POA and see if they can get a hold of the life insurance company, because that is just utter silliness. I'm just assuming that most elder law attorneys also draft good POAs. I mean, again, I know I'm biased, but it should have sufficient language in it then. So I would have the lawyer call and yell at them. That's what I would do, but I'm a lawyer, so that's really frustrating. I'm a healthy person in my 20s. What documents do you suggest I prepare? You do currently have a life insurance policy. Great question. So I think everybody should have powers of attorney. Again, we just don't know what the future holds. So a power of attorney can actually help you with stuff now. I once bought a car without my husband, but his name is on it because he could not be there. He was teaching, he's a teacher, he was teaching school. So it's a matter of convenience, but it's also there in case something terrible happens. I don't know what the future holds. I don't have a crystal ball. And so I think it's a great document to have in place. I think wills are great too. Now, if you do not have a will, your wealth will go to your legal next of kin. So if you're married, it'll go, well, partly to your spouse, unless you have kids, and then your kids and your spouse will split it. If you don't have a spouse or kids and you have parents, it goes to them, and then siblings, and so on and so forth. So if you are okay with that plan, you can live with it. But if you want your money to go somewhere else, you should have a will. And so really the POAs, though, would be the number one thing that I say you should have. So again, because they just provide so much flexibility in the future. These are all good questions. Thank you, guys. All right.
Well, I don't want to go to a lawyer. I'll be paying to hear this crap.
Pardon?
Hold on a minute, I got.
Okay. I'm gonna mute her. Okay. All right. Let's talk about paying for care. So if you need long-term care, somebody you know needs long-term care, let's talk about how you pay for it. So I don't know if anybody has relatives in a nursing facility, but it is expensive. And so it is really the greatest risk to accumulated wealth. It's no longer taxes. Again, we're not paying estate or inheritance taxes unless you have close to $13 million now. So that's not really a risk for most of us. So when you're doing estate planning, it's important to think about paying for that future health care. So who's paying for it? So right now, Medicaid is the primary payer of most people's nursing home bills. You can kind of see this lovely chart here. Private pay is a small percentage. Medicare pays a small percentage. Long-term care insurance pays an even smaller percentage. So just please be aware of that. Long-term care insurance. I always like to highlight this, especially for people who maybe their 50s and 60s and are healthy. Long-term care insurance could be a great resource. It does provide a lot of flexibility in that it can pay for different types of care. Medicaid is paying only for skilled nursing care. It's not paying for assisted living or independent living or most types of memory care or personal care. So this long-term care insurance could be a good option if you want flexibility in the type of care you have one day. Additionally, I love it because it kind of gives you some buffer time. So if you need some type of care and you know that your health is declining, using this long-term care insurance creates kind of a time buffer so you can do some Medicaid planning if you need to. Also, the younger you are, typically the cheaper it is. And then I have some questions on there that you should always ask about the policies. Does it cover Alzheimer's or dementia? Some of them don't. What's the daily benefit? That's how much it'll pay per day for your treatment. How long will benefits be paid? Is there a maximum amount? What types of care will the policy cover? Again, it could be a whole variety of things. I've seen ones that just covered skilled care. I've seen ones that will even cover in-home care. So there's a huge variety there. You want to make sure also that you ask what the exclusion period is. And so that is a period of time where you have to meet the level of care, but they will not pay benefits. So it can be as little as 30 days. Or I've seen it as many as 180 days, which is 6 months where you have to pay out of pocket before the long-term care insurance will kick in. So be aware of those things. A lot of these policies now are being paired with life insurance policies. So it's kind of like you either use it as long-term care or your family gets the benefit as a life insurance benefit. So those types of policies are out there. I don't sell them. I just know they exist. So I had a client today who is going through planning for her husband, and he is currently on a long-term care insurance. And we're actually very happy that he has it because it's allowing us to do a lot of planning for them. It's providing that buffer time. All right. All right. Just a couple quick notes on Medicaid versus Medicare. These are two terribly named programs. They're very confusing. And even as an attorney who practices in this area, sometimes I say the wrong word. But it's really important to know the difference because they cover two very different types of care. So Medicare, of course, is that government insurance program that you can get at age 65. There are some reasons why you can get it earlier, but generally speaking, we can all get it when we're 65. It's a federal program and it pays for limited long-term care. So it is going to pay for long-term care when you have been admitted to the hospital for 3 days, admitted 3 nights, 3 midnights, not an observation status. You have to ask. And it will pay for 20 days and a part of up to an additional 80 days for a rehab stay in a nursing facility. And after that, you are out. Okay. So 100 days max. I see very few people who actually make it to day 100. So Medicaid is the government assistance program. It's a federal program that's instituted by the states. And so that means it's different in every single state. So be aware of that. It is needs-based. So it is based on your financials. It's also based on your medical needs. And this is the one that pays primarily for long-term nursing care in Kentucky. So, all right. Why do we, so just some Medicaid basics, why do we want to know? Because it's the program that pays for most long-term care. Okay. It's the biggest risk of our money. And there's 76 million baby boomers. So it's going to be something we all need to know about. All right. So there are medical criteria and financial criteria. The medical criteria is really that you need substantial assistance or fail at 2 of your 6 activities of daily living: bathing, eating, transferring, moving from like a chair to the bed, toileting, continence. So all of those things. So you have to fail at 2 of them. So when we're talking about Medicaid eligibility, that's usually the easy one. Okay. The financial one is much more complicated. There are criteria for income and resources, which is what Medicaid calls assets. So your income is that you have to have $2,742 a month or less, and that is a gross number, not a net. If you have more than that, you can easily fix that with something called a qualifying income trust. It's simply a separate bank account you have to operate for the amount over the limit. And so that number also changes annually, not to be terribly confusing, but that's what Medicaid does. Resources, your assets. For a single person, you can have $2,000, a prepaid funeral, and a car. That's it. Married couples are much more complicated and have to go through something called a resource assessment. Okay. So again, single person, $2,000, prepaid funeral, and a car. There are some resources that do not count. Okay. In Kentucky, the principal of your retirement accounts does not count. That's really important for people who have their wealth in their IRAs or things like that. They do have to be in a payout status, but the principal itself does not count. Medicaid's not going to make you defund your IRA or your 401k to qualify. All right. Married couples. If a couple is married and one of them is living in the home is also exempt. Each partner in the couple can have a car, and they can both have a prepaid funeral. What the resource assessment does is it looks at all of the other things. So it looks at the bank accounts, the cash surrender value of the life insurance policies, which is something that gets overlooked a lot, stocks, investments, things like that. And they put all of those into a pile. They do not care who owns them. They don't care which member of the couple owns them. They don't care if you had it before the marriage. They don't care if it was an inheritance that you recently received. They put all of that stuff in a pile. And then what they do is they divide that number by 2. The spouse staying at home gets to keep half, and the spouse going to the nursing home gets to keep 2, which means his half has to be spent down to $2,000. So if there was a couple with $60,000, the spouse staying at home gets to keep 30, and the spouse going to the nursing home keeps 2, and then they have to spend down $28,000. So there are high ends and low ends to that. If a couple's resources are under $60,000 and the spouse staying at home wouldn't be able to keep this low number here of 29,724, she's going to get to keep that, okay, regardless. If the assets are more than like $300,000, Medicaid is only going to let the spouse staying at home keep $148,620. Again, these numbers adjust annually. I always tell people it's better to have a resource assessment done when you have more stuff than less, because half of more is always more, okay? You have to actually go through this process at the Medicaid office, and they will give you an official document that shows how much you need to spend down. Generally, what we do when we work with married couples is we try to use that spend down on things for the spouse staying at home to improve that spouse's lifestyle. So generally speaking, I usually put in my scenarios, I put the man in the nursing home first. Sorry, guys. And so the wife in this, if her spend down is $28,000, she could do a couple of things, just a couple of easy things. If there's a mortgage on the house, we're going to pay that mortgage off or pay down on the mortgage. If she needs a new vehicle, we can trade in her old car and use the spend down money to buy her a newer car. If she has low income, we could possibly buy a spousal annuity. It's an immediate annuity and it has to be Medicaid compliant. And so we could raise her income and take all of that money and just all that spend down money and just turn it into a stream of income for her. So that there's lots of options. She also could fix up the house. Anything she would do for her and her spouse would be fine. So again, lots of options if you are married. Okay. Okay, so Medicaid gifting. I always like to cover this, especially since I've mentioned in my POAs that I want to see gifting. Well, why do I want to see gifting? The first thing you need to know is Medicaid has a 5-year look back. Okay, so any gift made within 5 years, Medicaid can look back at and give you a disqualifying period of time as a penalty. Medicaid does not care about IRS annual gift tax exclusions. They don't care. Medicaid and the IRS do not play together. If you have been making gifts of $17,000 to your children, Medicaid will count them as a gift. Right now, what they do is they add up all of those gifts you've made in the last 5 years, and they divide them by the daily cost of nursing home care, which is about $270. And that is the number of days that the person who made the gift is not qualified for Medicaid, but they have to have already been eligible before their penalty period started running. So that means if they've not completed a spend down or something like that, their penalty period has not begun to run. So you just need to be aware of that. There are some exceptions. Spouses can always gift to each other because, again, Medicaid doesn't care whose name's on it. There's also exceptions for the house. If there's a caregiver child, a child who has lived with a parent for 2 years and provided care, the home that is owned by the parent can be transferred to that child without a penalty. If there's a disabled child or a minor child, the house can be transferred to them or to a trust for their benefit without a penalty. Additionally, if you have a disabled child, you can transfer all of your assets to them and immediately qualify for Medicaid without a penalty. So that is an option. Generally speaking, we do that through some sort of special needs trust for that child. Okay. If there has been gifting that has been done, we can do something called half a loaf gifting to cure the gift part way. So essentially what we do is we make a gift. So earlier today I was playing with the number 300,000. So most people don't have that much to gift, but say somebody made a gift of $300,000. Well, Medicaid is going to give a penalty of, it's going to be about 3 years of ineligibility. So for a year and a half, the family could give back the money as needed to the person who made the gift, and that person could use that money to pay their nursing home bill. And 1 year, 6 months, and 1 day after the gift, after the Medicaid penalty, we could go into Medicaid and make a new application, say, hey, we returned some of the money, we need a new gift penalty. Well, what Medicaid's going to do is they're going to recalculate the gift, And in this scenario, it's going to be a 1 year, 6 month penalty. But we're there on its day. Well, I'm not going to count the days. So it's 1 year, 6 months, and 1 day later. So we're actually there 1 day after the penalty period. So Medicaid is going to say, hey, you've already served your penalty period, so you're eligible for Medicaid. So what has happened is the family has been able to gift about $150,000 and save that money, and they're Medicaid eligible at that time. So that is a possibility. I do not suggest you try this without a lawyer. It's very confusing. It can be very confusing with a lawyer. So because the Medicaid, you have to work through the Medicaid office and you have to return the gift just so. But that is an option for what we call crisis planning. If somebody needs care unexpectedly, it can be a really good way to save money. The nice thing is by making these gifts, typically what is done is the family puts the money aside and uses it on the person in the nursing facility. Not always, but that is typically the goal. Because once you're in a facility and you're on Medicaid, you only get $40 a month for your personal care needs. Because personal care needs are things like your shampoo, your haircuts, manicures, things like that. I like to joke that I've already spent $40 on myself today. It's just not enough money. So, all right. Susan, I see your question. I'm going to address it in a little bit. I want to finish this Medicaid stuff first. So Medicaid, that's where we're going. Come on, click. There you go. Medicaid estate recovery. So this is something I always like to let people know about because Medicaid doesn't want you to have your cake and eat it too. Okay. So if somebody on Medicaid passes away owning things, Medicaid has a right to come back and recoup the cost. All states are mandated to pursue estate recovery. The reality is most states don't have the money to actually do it. So estate recovery is kind of spotty. It's not very consistent. I always like to warn people. There are exceptions to Medicaid estate recovery. If there's a surviving spouse, they're not going to do recovery. If there's a disabled child, or if there is less than $10,000. There is also an exception for a hardship. The hardship exception is typically for family farms. So it is essentially that there is this asset that a family member is using to get all or most of their income from. So sometimes people call it the family farm exception. That's not exactly what it is, but that's what it is, what people are referring to. Okay, let's move on. VA benefits. So if you are a veteran, especially one that has a service-connected disability, it's important to be talking to your VA representative about this. There are benefits there. Veterans who have a service-connected disability of more than, I believe it's 70%, can have their care paid for at a VA nursing home like Thompson Hood. So that's really important, that VA service-connected disability. All right. Just a couple of last pointers. I always like planning now, creates peace of mind. It helps get your wishes down, your desires down, what you actually want. Makes things easier on your family upon death and gives the ability to somebody you trust and you have chosen to make financial or medical decisions for you, and avoids that guardianship process and starts looking at the cost of planning for long-term care. Right. And then I did have a question. Okay.